Good afternoon, everyone. Welcome to this special webinar on making arbitration work for your client. The webinar is focused on three aspects of international arbitration proceedings: tribunal selection, document production, and the presentation of witnesses, and how to optimize the process to achieve a fair resolution of complex disputes. We'll be covering a wide range of topics today that fit within the three stated aspects and plan on conveying some key differences between arbitration and litigation, as well as approaches on getting the best results from arbitration. For tribunal selection, the speakers will discuss topics such as what's looked for in a chair and how to make these decisions effectively, for example. Secondly, for document production, the speakers will cover points such as contrasting arbitration to typical discovery and litigation, how to use the limitations of discovery and IVA rules to your advantage, and how to defend against these points, amongst others. And thirdly, for the presentation of witnesses, the speakers will address topics such as how some rules are more relaxed in arbitration that allow for controlling the narrative, contrasting arbitration with a bench trial setting, and so on. Today, we're happy to be joined by leading experts in the field of arbitration. Liz Snodgrass is a partner at 3 Crowns in the Washington, D.C. office. She's highly experienced in international arbitration matters with more than 2 decades of experience with disputes in Africa, India, and Asia. Liz is noted for experience covering disputes involving states and state entities, and she focuses on both commercial and investment treaty arbitration, especially in the upstream, energy, power, and mining sectors. Scott Vessel is also a partner at 3 Crowns in the Washington, D.C. office. He covers complex international investment and commercial arbitrations, specifically in the oil and gas, energy, mining, and construction sectors, but his experience also extends to sectors such as gaming, tech, defense, and agribusiness. He's also served as an attorney advisor at the U.S. Department of State. Christopher Gazarian is a general counsel at DreamHost, a Los Angeles-based web hosting and cloud computing services provider that has been operating for more than 25 years. He has been serving as general counsel there since April 2016. Chris leads on due diligence operations for all M&A activity, is noted for defending the company against unnecessary litigation. And lastly is Mimi Lee, managing counsel at Chevron. She is an experienced litigation partner covering such areas as commercial disputes, international arbitration and litigation, as well as pre-dispute matters. She's been active in the role as managing counsel since 2008. With all the introductions out of the way, I'd like to pass on to Liz from here on.
Thanks, Nathan. And thanks to Legal 500 and especially to Mimi and Chris and Scott for agreeing to allow me to pepper them with questions for the next hour or so. And thanks to everyone who's tuned in to this webinar. Welcome. As Nathan said, my name is Liz Snodgrass. I'm a partner with 3 Crowns, a firm that specializes in international arbitration. Together with my partner, Scott, and with Mimi and Chris, who are here to bring the perspective that really matters, the perspective of the parties who choose and use arbitration, we hope to share with you some insights about how the process works and how you can make it work for your clients. We're going to be having a dialogue for the next little bit. I'm going to be asking some questions and we're going to be offering some answers, but I believe there's a feature, and Nathan can tell us how this works, for you to ask questions in a chat box, which we'll be addressing at the end of the session. Before we jump into the conversation, I should just note that all of us speaking here today are doing so in our personal capacity, and we're not speaking on behalf of any of our clients or any employer. So just by way of setting the stage for our discussion, as you all know, if the parties to an international or cross-border contract do not make any provision in the contract for dispute resolution, there can be uncertainty about how or where, in what forum, disputes will be resolved. And that uncertainty can result in an unhelpful race to the courthouse, and it can even lead to uncertainty about how the contract will be interpreted, given the different approaches to choice of law in different jurisdictions. So Contract Drafting 101 is that you're well advised to say something about dispute resolution in your cross-border contract. First question, what drives the choice of arbitration as a method of dispute resolution specifically? And to address that question, I'm going to turn first to Chris. So Chris, what are the main reasons that your company opts for arbitration when it does, instead of litigation?
Thank you, Liz. I think in a survey that was done recently of in-house counsel, cost time and inexperience were the top 3 leaders when it comes to complaints of litigation. And then when you think about it, one of the biggest issues we have, especially in the tech field, is when litigation arises, you often are afraid of the jury. You're afraid of what's going to happen in court. You're afraid of the costs. You don't know what you're going to be facing. And it's quite an uphill battle to outline and understand all of the risks involved. So when you talk about arbitration, one of the top benefits for us is the experience that is brought in by specialized proceedings and expertise. And so, the facts are determined by specialized practitioners rather than a jury of laypersons. And of course, time and money is also a huge factor. As we all know, once you're involved in litigation, even if you take a passive approach to it, it still costs you a ton of money. And on the flip side, arbitration, if done properly, can be much cheaper. So I think those 2 benefits are extremely attractive for companies like ours. And those are the reasons why we usually opt for arbitration, and especially in an age where everything is being done digitally and cross-border, and where companies are expanding extremely quickly and globalization is a hot topic. I think there is a lot to say about arbitration and the benefits that it could bring to every company out there.
Okay, so cost and time efficiency and the expertise of the decision maker. Mimi, are those the same considerations that come into play in the disputes that you handle, or are there different factors that you focus on?
I think Chris raises really great points, and I would tend to agree with them. Everyone's looking to save money and save time. I think I would only add that when we choose arbitration over litigation, it really depends on the jurisdiction, and even the format of arbitration. We're just looking for a level playing field. We want a dispute to be considered and resolved in an objective manner, where the decision maker, let's say, will follow the rule of law. That is something that we rely on in every jurisdiction. So those are the things, in addition to, I guess, finality with arbitration, particularly if you have a dispute resolution provision where you have waived the right to appeal, you've agreed not to appeal, and you've got your counterparty who is going to abide by that. You do have finality, whereas in litigation, often it just goes and goes and goes, in addition to discovery and things like that. But I think we're probably going to get into those aspects a little bit later.
Yeah. I might just add a comment there. A couple things that you didn't mention, which to my mind are really 2 bankable reasons to choose arbitration for an international contract. And those are, first of all, certainty as to the enforceability of your choice of forum, right? So an arbitration clause is really securely enforceable. And then second, of course, the mechanism for enforcement of arbitral awards under the New York Convention, which there really is no parallel for outside of the European Union for enforcement of court judgments. So we had a good list there: cost and time, expertise of the decision maker, particularly in specialized industry sectors, neutrality. You mentioned, Mimi, the finality of the decision, and then I would add to that sort of the security of enforcing your agreement about where to resolve disputes, and then once they are resolved, the enforceability of the outcome. Follow-up question for you, Mimi. Okay, so having chosen arbitration for the reasons that we've just talked about, what are the biggest differences that you see between arbitrating a dispute and litigating a dispute, sort of from the user's perspective?
Sure. I think it's, going into a little bit of what we've just, talked about in terms of why we choose arbitration over litigation, but without being repetitive here. I think on the front end, it's sort of the ability to shape the way you want to resolve a dispute. it's almost like a prenuptial, right? You're entering into a contract with a counterparty, and when everything is rosy, I mean, but that's when it's the better time to map out how you want to resolve a dispute if a dispute arises down the road. And so it gives both parties an opportunity to control their destiny to some extent. And harkening back on some earlier comments about efficiencies of time, you can also shape the methodology, how you want to resolve your dispute leading up to formal arbitration versus litigation. You can shape who will how to deal with costs for prevailing party. Do you split them? Does it are they off the table? Right to appeal, same thing. But I think one of the challenges there is you are trying to predict and not to disparage my transactional colleagues, but it's, I don't know about everyone else on the line here, but typically it's if someone's negotiating a major deal and then they sort of call you at the 11th hour to say, hey, we're doing a dispute resolution provision, and by the way, we're signing tomorrow, what do you think? So it's always kind of thrown at as a last sort of item to address, this dispute resolution provision and governing law sometimes. So, just getting it out there that those are two very critical pieces that can really impact you as a company years down the road, where you're not even anticipating there to be that there could be a problem. But there is not to get too far off the trail here, but there is a challenge sometimes in trying to predict all the various scenarios and making sure your dispute resolution provision isn't too heavy-handed, isn't too onerous for a relatively nominal dispute. If you've got a counterparty who is acting in good faith and really wants to truly resolve an issue that's relatively minor in a straightforward way, or if they're sort of teeing that up for something bigger, then really you can't help that. But but in theory and in the bigger picture and in the vast majority of the cases, there is one very good plus is indifference, is just being able to shape that versus in litigation you don't know which judge you're going to have, and in the US you don't know what, if it's jury trial you have no idea what that's going to look like. Even if it's a bench trial, you don't know what your judge is going to look like, and sometimes you have a different judge for trial, so it's just a lot of uncertainty there. So I would also say in terms of differences, in litigation, of course, which is a plus and minus, there's a lot more transparency. There, everything is public record and searchable. And, granted, we're not, in the judge's chambers or in the jury room listening in on what's going on, but there's a little bit more and it's transparency, and it's incremental as you're going through, either if it's law in motion or, you get an initial look at how the judge is going to deal with a particular matter. But in arbitration, it cuts both ways. It's a black box, right? And it's confidential, which is great in some respects, but it can present a challenge in others.
Yeah, just to draw that out, Mimi, I hear you saying it's a black box in a couple of respects. One, it's a black box in the sense that it's typically a confidential proceeding. So it's happening in private. There isn't public access to the proceedings. But it's also a black box, in my experience, in that you don't get those interim indications from the decision maker, kind of how they're leaning. Right. You don't get a ruling, motion to dismiss or a motion for summary judgment. The arbitrators keep their cards pretty close to their chest on how they're feeling about your case. So it's a process that builds up to the main event, which is an evidentiary hearing, often 12, 18, 24 months after the process kicks off. My light just went out. Sorry, I'm gonna move. So my office realizes I'm still alive. And then you get the big reveal, sort of how the arbitrator is meaning. So that is, I think, a distinct difference between arbitration and litigation.
Totally agree. And I mean, not that I'm enamored with the discovery process or law in motion, but you do get, very good insights, especially if there's a active, judge who's, hearing your law in motion. And if you have, you're the judge who's going to hear your case through trial, then you have all that lifetime of your matter where you get to kind of tell the judge about the case. The judge is learning about the case. You're earning credibility, hopefully, with the judge on repeated instances. So that can weigh in your favor, but but again, it can cut both ways. It's a plus and a minus depending on I guess what side you're on.
Same question to you, Chris. What are the biggest differences you see between arbitration and litigation? While I wave my arms around here.
I think Mimi summarized it beautifully. There's so much that is beneficial mostly, right, when it comes to arbitration, especially for companies like ours. I think one of the things that I tend to notice with arbitration is that it's usually a lot more specific when it comes to one or two different issues that people want to fight over, want to solve. For example, like litigation usually is a story. It's a huge drawn out process. And like Mimi said, there are so many steps that you go through, and it's a long drawn out ordeal. I feel like when it comes to arbitration, when the parties agree to it or it's in the contract, it's usually, in my experience, just a couple of issues that are central to the conflict. And so the parties cannot agree to these things, and therefore we go into arbitration to solve this specific issue, as opposed to litigation, in my opinion, where it may be multiple issues that you're fighting over, and you have a lot of different things that you need to establish and show the court. And so it almost feels like litigation is a story and arbitration is a single chapter in the relationship, and it's just there to solve the issue, which is why I think it's so attractive to so many businesses, because none of us want to sit there through our litigation, go through filings, go through hearings and file motions. It's a drawn out process. So I think that's one of the biggest differences I see. And Mimi also touched on privacy, which is a huge deal in my opinion. I feel like while there are ways to work around this on both sides, arbitration clauses usually call for confidentiality, and arbitrators often enter confidentiality orders. And I think ICDR trains a lot of their staff to follow state-of-the-art privacy and confidentiality practices, and they can issue protective orders, which is much more, I would say, is a much more favorable position for a company to be in, as opposed to going into litigation blindly. So that's another big pro for us that I see for many companies who take advantage of arbitration is, like Mimi said, you're not really filing out there publicly. There are not many eyes on the issue, especially if it's an issue that you don't want a lot of attention around. It could be something that's very beneficial.
That's interesting, because I think there may actually be an interesting connection between the 2 points I heard you making, Chris, which is that arbitration, is part of a suite of ADR techniques, right? Which can be part of resolving disputes in a relationship that hasn't entirely broken down. Now, I can speak from experience. Arbitration can also be part of resolving disputes in a relationship that has entirely broken down, and can be, in fact, quite combative and quite, total war. But it can be a sort of consensual, incremental, constructive, we're not getting a divorce, we just need to know what the contract means, kind of way of approaching dispute. And I wonder whether the second point you were making, which was that privacy, the fact that it isn't happening in a public space, enables businesses to engage in the right circumstances, in circumstances where there are those business disputes and just a misunderstanding or a dispute about what the contract means, engage in a relatively lower temperature way around disputes over, what are the right, what is the right outcome here and under a contract. So I think that's the sort of the ideal, is that the privacy of the process enables business disputes to be resolved in a non-emotive way, in a way that isn't disruptive to the relationship. And it can then continue once there's clarity around, what the terms are, and everybody goes forward and the relationship continues. It doesn't always work that way, because sometimes the rupture in the relationship is so significant that it's just as combative as anything, might be in litigation, but that's a different situation. Okay.
Liz, I would also add to your comments that, sometimes, particularly when you're dealing with a counterparty that's a state-owned entity, oftentimes you are able to, as you approach the merits hearing, or hopefully well before that, you do have a better sense of kind of what's really going on at the other side. And, oftentimes, again, with a state-owned entity, they have a need to have a neutral panel issue a decision really for political cover. And it's unfortunate because, you know, you have matters that should resolve, and you could normally reach a resolution, but you know, I don't sit in that role, so I can't totally understand what the pressures, you know, different kinds of pressures that they're dealing with, but oftentimes, you know, they need political cover, so you do have to go through all the way to an award, you know, to get resolution.
Yeah, that has certainly been my experience, is that sometimes it's an important function to have clarity and to have the imprimatur of an award saying this is the answer and now everyone has to live with it. Okay, in the interest of time, we might move on to focus on the three topics that Nathan identified for us at the outset, which are three aspects of how arbitrations are actually run, how they actually proceed that set it apart from litigation. And those are tribunal selection, document production, and the presentation of witnesses. So obviously, turning to the first of those, one of the biggest differences between litigation and arbitration is that in arbitration, the parties generally choose the judges, the arbitrators who are going to decide the dispute. So in most arbitrations of any significant size, as you all will know, the parties will agree that there should be three arbitrators, giving each side the chance to appoint one of them, and the third arbitrator, who's the presiding arbitrator, either chosen by agreement of the parties or by a neutral appointing authority. As you'll also know, in the United States, there was historically a tradition of party-appointed arbitrators playing a role essentially as open advocates for the party that appointed them. So the dynamic historically was that the two party-appointed arbitrators would vie for the vote of the third presiding arbitrator. And when that was the system, it was not unheard of for a party-appointed arbitrator to be formally aligned with one of the parties, maybe to be their former banker or their former lawyer or even a former employee. And there was no pretense that that party-appointed arbitrator was neutral vis-a-vis the parties. His role was to be an advocate for his side. Now, in international commercial arbitration and international arbitration generally in the United States, that practice has now been abandoned. And there is now a clear duty on all arbitrators, including arbitrators appointed by parties, not only to be formally independent of the parties that appoint them, but to appear to be independent of the parties and impartial as between the parties and in respect of the issues that are being brought before them. Now, this kind of independence and impartiality of arbitrators was pretty much always the rule in Europe and elsewhere. So US practice in international arbitration has evolved to be matching the practice across the pond. So as you mentioned, Mimi, it's this neutrality is one of the things that attracts parties to choosing arbitration. But bearing in mind this requirement that arbitrators are to be and have a duty to be and remain formally independent of the parties and impartial as between them, selecting an arbitrator is nevertheless, you know, a critically important strategic decision in arbitration, probably, if not the most, one of the most important decisions you make. Because even a scrupulously neutral arbitrator is going to have intellectual predispositions, temperamental predispositions that are going to make her, you know, more inclined to be persuaded by the case that you're going to have to put to her, right? So what I'm going to do now is turn to the experts here to delve a little bit more into the art and science of tribunal selection, balancing a tribunal. And I'll start, Mimi, with you first, with just the open question. What do you look for in an arbitrator appointee?
Yeah, thanks for that question. I don't know if I'm an expert, but I can share from my perspective. You know, in addition to all of the really great and valid points you made, I would add, you know, we're looking at the arbitrator's experience, their reputation, their availability. You know, it's great if you have a stellar arbitrator, but if they're booked, you know, forever, that can be a challenge. You know, and willingness to, I guess this goes to reputation, but, you know, willingness to actually roll up their sleeves and review the materials and be prepared, you know, from the very beginning. You know, we've had instances, I'm sure like many others out there, where they don't really, you know, some might not get into it really until you're farther, further down a path. And it really does help, when you're even having the initial conversations, even the procedural stuff, administrative stuff, if they have a better sense of what's really going on, or our willingness reputationally to really get involved, really engage and understand, get their arms and legs around what the matter is about. And that also goes to availability. That's important. It's also important to have kind of a proven record of being willing to take a position, and take a stand. I mean, too many times we've seen arbitrators who just sort of want to, who want to kind of keep everything sort of cordial and, friendly, and give, and there's some fear of, having the award being challenged for, down the road for a variety of reasons, that where they're not, they don't have the courage or willingness to make the tougher calls and call a party on, some delay tactic or, gamesmanship or, deliberate delay. So, that's something that we like to see. I mean, going back, briefly to the conversation we had earlier about the confidential nature and the black box, sort of aspect of arbitrations, that can be a challenge, getting all of that out there versus, when you have litigation, you can go in and sit in and observe a trial that's going on to see how a given judge is behaving, or, what their temperament's like, or even outside counsel, what that looks like. But it's more of a challenge. It's sort of, word of mouth, and, you have these databases, but they're helpful to a point. So, but anyway, but back to your original question, those are some of the other qualities we look for. I think it's, you said it's one of the most important. I totally agree. It's one of the most important decisions you're going to make in your dispute resolution process. And, it is ironic though, how challenging it is to get good, solid information. And I think as a result, we end up going, oftentimes parties go back to arbitrators that they've used before, because, you've got a multi-million-dollar, sometimes billion-dollar dispute, and to go with sort of an individual that you don't know, only saw speak at a conference for 45 minutes, that can be a bit risky. So those are some of my thoughts.
Yeah. Chris, same question for you. Similar considerations or different considerations?
No, very similar considerations. I think there's always a balancing act when it comes to choosing arbitrators, and I think that the difficult part for us is we tend to, as Mimi said, there are a lot of procedural considerations. You have to obviously find someone who is available, because as she correctly pointed out, often many arbitrators have a calendar that looks worse than our calendars. And but in general, I think one of the main things we look for is what I mentioned in the beginning, which is basically tech savvy, specialized comprehension of the business and tech world. We look for people who are in the know, and they understand exactly what the issue is. They understand our business, our clients, and our issues, and they're not coming in blind, because many arbitrators may tell you that they have a lot of experience in an area, or they have a lot of expertise they can offer. However, they don't always understand the core issues that are involved, for example, in a tech company. And if you don't understand the core issues of what's going on behind a tech dispute, then it's really difficult to gain the specialized expertise and opinion that you need from arbitration, which is, like we mentioned, one of the biggest benefits of avoiding litigation. So that's one of the biggest issues for us. And I think there's a fine line between finding an arbitrator who can balance and appreciate the substantive issues that we deal with, and have the procedural issues down, in terms of their schedule, the way they work. And, just speaking of tech in general, we also look for tech savvy arbitrators who are willing to incorporate a lot of the new technology that we've seen in arbitration over the last few years. I think that's a big deal that we haven't really touched on yet, but one of the keys we see in arbitration is that it seems to keep up with the times a lot better than litigation. And even though COVID changed quite a bit in litigation, and things have been improving in terms of remote access and remote filings and all these different things, I feel like arbitration still has the upper hand in that area. And when you find arbitrators who are willing to play along and incorporate that technology, it makes life infinitely easier because you don't have to go through the traditional courtroom procedural issues that you do with litigation. So I feel like those are some key areas that we look for. And Liz, I think you mentioned this, but obviously you meet arbitrators often, you see them speak, sometimes you find them interesting and you feel like they may be a good fit, but there really is, it's an art picking an arbitrator, and you really need to invest a lot of time and energy to choose the right person before committing to this process.
Great. Thanks, Chris. I'm going to turn to Scott. I'm going to trespass on the privilege of partnership and throw him not only the question we talked about throwing him, but also a question that's been raised in the chat. So first question is the calculus in choosing an arbitrator different when you're selecting the third or presiding arbitrator? And then a question that's been raised by one of the attendees, which is what are some of the ways or techniques that can be used to increase the diversity of arbitrator appointments? And you can begin addressing that, and then we'll open that up. I have some thoughts, but Mimi and Chris might have some thoughts they want to address on that while we're on the issue of arbitrator selection. So over to you, Scott, and then we'll go back to the rest of the panel.
Well, thanks, Liz, and thanks to Mimi and Chris for highlighting really the key things you're looking for in arbitrators, which are the same things you're looking for in a chair, but with certain nuances. And part of it is because the chair will be both captaining the procedure, but also captaining the drafting of the award. So you really want to make sure that your chair has the substantive knowledge and experience to be able to do that, not only to decide the issues correctly, but to draft an award that will deal with them appropriately. But I would focus particularly on procedure, because there is a lot of flexibility in arbitration procedure, and there are certain proclivities in terms of the style of the procedure that can have a real impact. We're, those of us who are operating in this space are familiar with there's the big divide between memorial style procedure and pleading style procedure, which the main difference is whether the witness statements and expert reports come in with the written submissions or whether they come in later. And often going into a case, you will have a strong preference as to which of those you want to follow, and that may inform your selection or your preferences in terms of both your co-arbitrator but also the president. But you will also want to consider how the president will manage the proceedings. In other words, will they have a firm hand in terms of some of the sort of procedural nonsense that can go on? Will they give the parties space to try and agree things, or will they try and impose their own view? And depending on the parameters of the case, you may prefer one or the other, but you will certainly want to be thinking about how you, based on your experience and familiarity with the candidates, how they would be likely to approach these procedural questions. The availability question is particularly important. Now, it may, again, cut in different ways. If you're a reluctant respondent and you want the case to drag on forever, you may be attracted to a very busy arbitrator, although it's quite dangerous to have a chair who's too busy, because you need the chair to be engaged from the beginning so that they can be up to speed on what the case is about, to deal with the procedural issues that come up as it goes along, and so on. So you really want to make sure that your chair is going to be on top of things from the beginning and will be responsive to urgent points that come up. And the third unique element or particular element about selecting chair candidates is that, at least in the sort of normal, the most common approach, where you have the co-arbitrators and the parties involved in selecting the chair, you will want to discuss with your co-arbitrator what they have in mind, whether they have experience working with the different candidates, who do they have a good rapport with, because coming back to the preceding question of selecting a co-arbitrator, one additional point for me is you want to select somebody who will be influential on whoever the chair is. And so those relationships can be important to getting the right composition of both co-arbitrator and chair, so that you know that they will be listening to each other, they will be making sure that the parties' arguments are being heard and considered fully. So I don't know, Liz, if you want to invite reactions to that before we turn to the diversity point.
Yeah, I don't know if there are any reactions on the selection of a chair point from Mimi or Chris, or if we want to move on to the important question of diversity on tribunals.
No, I agree with Scott's good comments. The one of the key pieces, considerations, as well as Scott, you mentioned, is just what is that dynamic going to look like, between the three ultimately. And it's, again, I won't say it's a total black box, but it's also, who knows from the outside, right? You can only sort of best guess, well, how is, Mimi really going to interact with Liz when, Scott's there? And, reputationally, you can say, well, Mimi usually, we think she's more like this, but once we put Liz in the room, then it's going to change a little bit. And then if you add Scott, that's, forget it. And thank God Chris wasn't involved. But it's just, it's just personalities and how they, riff on each other, I suppose, can be challenging. But yeah, it's critical. And the only thing other thing I would add is that, at least for us at my company, we're really trying to get to know, more of the arbitrators out there. We're the users, and we rely so heavily, nothing against our outside counsel at all. I mean, that's a key source of information that we rely on. We rely on their expertise and their experience out in the field. But as the end user, because the decision that they make is going to directly impact us, I sort of see it as, our obligation to make sure we're getting to know who else is out there. And, without stealing the conversation on D&I, that folds into it as well. I mean, there are so many great arbitrators that are, I would say, not just in the D&I space, but it's just the lesser known, the underused, that are out there. And how do we get to know them? And both in terms of, diversity, in terms of, geography, ethnicity, nationality, all that stuff. But there's so many great ones out there that we just aren't exposed to, and just finding a way to get to know them better beyond, seeing them speak for, 30 minutes, on a panel at a conference, and getting to know them better. So, we're really trying to undertake an effort to get to know arbitrators in, a level playing field sort of way, such that they're not going to get, challenged if we do appoint them later. But, it would be good, if we could all put our heads together and figure out how to better approach this. So that's all I have to add at this point.
Yeah, I think that's exactly the right segue, Mimi, to the diversity and inclusion question, which I think the key is to get to know more arbitrators. Because you made a comment earlier, which was, you often end up going back to arbitrators that something about, having seen them before, because the stakes are high, and it's hard to justify, taking a risk on an unknown or relatively lesser known appointee. Scott, I don't know if you wanted to address kind of some of the techniques that firms and counsel and users can use to increase or try to increase the diversity of arbitrator appointments.
Yeah, thanks, Liz. Well, I think you've highlighted the key challenge to improving diversity, particularly when you're dealing with party appointments, which is that there's a strong tendency to look to known quantities, look to people you've seen before, and that creates this kind of barrier to entry to new arbitrators into the space. And so how do you overcome that? Well, there are a couple of things that certainly we try to do, and I think a lot of counsel try to do, is when preparing lists of candidates to discuss with the client, you need to make it a priority to include a balanced list, include a list that has different parameters of diversity gender in particular, but other ones that may be appropriate as well. And over time that will have an effect, but it's been very slow, in part because the names that you do the digging to find the great people out there, but the lack of familiarity still presents an obstacle. And so I think the institutions have a key role to play here, because where the institution is appointing arbitrators, most people, when they get their first arbitral appointments, it's from an institution rather than a party appointment. And through those initial appointments, then people become known quantities. And my sense is that the institutions are taking this very seriously. I think the LCIA's latest statistics were that they had reached parity in terms of the gender balance in their appointments, and the other institutions are pushing that along as well. So I think eventually that will trickle up into the party appointments, but it's very slow. But I'll pause.
I think the other things, I mean, Mimi, you put your finger on it. The other techniques that have been suggested or used are to make more widely available information about people's experiences with arbitrators. So to, a kind of Yelp or TripAdvisor for arbitrators. There's been dialogue about that for years. And I believe there are some sites that collect that sort of information. There are privacy concerns and, concerns about whether those reviews are accurate or appropriate. But I think those are all getting at the same issue, which is because of this black box process and the relative, close hold of information about people's experience with individual arbitrators, finding ways, accurately and safely to communicate that information out more widely is the fix here. It's the barrier to entry is a lack of information, and so finding ways to convey that information more widely. And so, as Scott mentioned, we have a policy which is to scrutinize and keep statistics on how are we doing when putting forward lists of arbitrator candidates to clients. How are we doing on achieving a more diverse mix of arbitrator candidates? The reason we focus on gender diversity, just to answer a question that may be asked, is because that's one that you can easily measure. It's more difficult to measure other types of diversity because statistics are not, people don't necessarily present themselves with a sort of identification. So, but the other kinds of diversity are equally important and are equally problematic, frankly, in the lived experience of people serving on arbitration tribunals. But it's a very important area. I think information is the answer to it. In the interest of time, I think we're going to need to move on to the next topic, which is not, frankly, possibly not nearly as interesting, but it's document production in international arbitration. And just to set that up very briefly, the first thing you might notice is that I'm not talking about discovery in international arbitration, and that's not a slip of the tongue. That's intentional. It reflects the fact that full US style discovery with its full panoply of different techniques is both rare and pretty much disfavored in international arbitration. Now, just to be clear, given the procedural flexibility that is inherent in the arbitral process, if the parties to a dispute want to have full US style discovery with a suite of depositions and interrogatories and requests for admission and all of that, they can certainly have it. But if one party objects to it in an international arbitration, they will be able to invoke a well-settled set of expectations and sort of soft law principles that will enable them to reduce the scope of discovery to something that will not look very much like discovery at all to a proper US litigator. So what am I talking about? Well, unless the parties have expressly provided for them or the rules they've agreed to provide for them, depositions are going to be exceedingly unlikely in international arbitration. Just one data point, I've been practicing international arbitration for 25 years, and depositions have featured in precisely 0 of the cases I have handled. Same for interrogatories, same for requests for admission. Those techniques just don't play. Instead, the focus in international arbitration is on a technique or a practice of exchanging requests for the production of documents, which I'm going to be asking Scott about in just a minute. But ultimately just one data point, maybe the most telling indication of how significant, or actually how relatively insignificant, discovery is meant to be in an international arbitration is this. The timescale for the whole document production phase of a typical international arbitration is measured in weeks, not months and years, as may be typical in a US litigation. And that schedule is only really feasible against the backdrop of a whole set of procedural norms and expectations that make discovery, if you call it that, or disclosure or document production, much, much less intrusive in international arbitration than in litigation. So just to bring Mimi back into the discussion now, given that landscape that's sort of supposed to be less intrusive, we can argue about whether it always is, would you consider that orientation, that less intrusive approach in arbitration, an advantage or a disadvantage of arbitration?
Yeah, I don't know if this is a trick question, but yeah, an advantage. I mean, yeah, I think as everything, it depends on your counterparty. If you've got a counterparty who is in there to prolong the dispute for whatever reason, they'll come up with various ways to manufacture, issues and questions and try to, prolong things and make it more excruciating. Painful, but then it goes back to your panel and your chair and how they're going to deal with it and if they're going to call them on it. But but I would say that is the same in arbitration or litigation. But generally speaking, yeah, it's the way it's supposed to work is it's far less intrusive and therefore far more efficient, far more cost effective if you if you're dealing with the document production issue in an international arbitration. But again, if there's a party with a different agenda, they'll find a way. I mean, I will say to your point, Liz, that at the outset, normally your counterparty has to make a good showing and convince the tribunal that they absolutely need X, Y, or Z, and then then it's up to you to respond and say yes or no. And they're going back to our earlier comments about making a positive impression on your judge or your tribunal, right? You don't want to come across as, I mean, within reason, but you don't want to come across as someone as a party that's being uncooperative, unnecessarily combative, withholding. Well, why doesn't this company want to share this? Is there something there, right? So you do still have to kind of balance how you're going to approach an answer or request in front of the tribunal, because you want to get those brownie points as soon as possible and collect them as quickly as possible. But it's also goes to reputation, credibility. So yeah, but generally, yes, my answer would be in the yes or no box. In the yes, it's it's less intrusive.
Great, very good. So Scott, I mentioned the document that it's more typically a document production exercise rather than what to a US litigator would feel like a full-blown discovery process. And what are some of the strategic implications of that approach, the approach under the IBA rules for document production, and how can a party use that document production process in arbitration most effectively?
Thanks, Liz. Maybe for those who are less familiar with the IBA rules, which are kind of the gold standard for how document production happens in international arbitration, it's worth recalling a couple of key features of those rules. So the IBA rules, the International Bar Association rules, are meant to be a universal set of rules that create an approach that's a balanced approach that's distinct from a sort of typical common law approach where you would have extensive disclosure of sort of all of the documents relevant to the case at an early stage, and the civil law approach where it's actually very difficult to get documents that are held by the other party. And so the idea behind the IBA rules was to adopt a principle that sort of in the first instance, each side should put their case with the materials they have, with the documents, with the fact witnesses and so on. And once each side has made their case with the documents they have, and sort of what are the key issues in dispute and what are the types of evidence that are out there, then you make these targeted requests for documents that the other side has. And when you go about it that way, it makes it possible to limit document production requests in a tailored way. So in order to justify a request under the IBA rules, you have to make a case as to, first of all, why the documents exist, why you believe the other side has them, why you do not have them. And then the key point is, why are they relevant to the case and material to outcome? And the materiality to outcome of the case is really the key requirement that keeps things under control. At the same time, it's one that invites often a lot of contention and debate amongst the parties. And I think it's useful to be very thoughtful about how to approach this when you're both drafting requests and objecting. And keeping in mind, for example, that in formulating your request about and your justification on relevance and materiality to outcome, it's an opportunity to educate the tribunal about what you see the case as really being about. What does it really turn on? So even irrespective of the outcome of the request or the objection, along the way, it's an opportunity to be sort of making your case to the tribunal at an early stage. At the same time, you do need to be careful what you ask for, both because if you ask for something, you will be in a more difficult position to object when the other side asks for something similar. But also, if you ask for something, you are advancing an argument that what you're requesting is material to the outcome of the case. And so you want to make sure that you're not sort of inadvertently accepting that certain points are really outcome determinative when on your case, they aren't. And given these elements, I think it really is it's a very important part of the process, but it's one that everyone loves to hate. And to be frank, not a lot of people out there are very good at this, which makes it very difficult for tribunals, but it's also a missed opportunity and maybe some own goals happening here. So I would recommend to both counsel and in-house teams to really recognize the need to devote the time and the effort and the skill development to doing this right, because there can be a lot at stake beyond the question of what materials are you going to get from the other side.
Yeah, just to pick up on that, I mean, just pulling on a few threads of the previous conversations. First of all, in terms of your tribunal, this really is, unless you've had a procedural incident early in the case about a request to bifurcate the case or some other procedural incident, this is the only substantive engagement that a tribunal will have with your case before it goes to a hearing in a plain vanilla case that has no other procedural incidents. So this is why Scott's observation that this is a real opportunity to advance your narrative. It's the only opportunity that you have. So Mimi was talking about how this black box experience that you have in arbitration. Law hits a vacuum, lawyers hit a vacuum. They'll use every opportunity they have to articulate, to make an incident, to make an opportunity to tell a story. And this is one. So don't waste it. And typically document production requests are exchanged simultaneously, which is the point Scott was making. Be careful what you ask for. They're exchanged simultaneously, so you don't know when you're making them whether you're going to get 75 or 3. And that's brilliant because it sort of makes everybody behave. Well, it's meant to make everybody behave. It doesn't always, but it's a great sort of, I'm sure some game theoretician could explain it better than I, but it's essentially you're gaming it. You're meant to then think, what do I really need? And what can I really justify? And then I'll be able to say, look, I've been good. I've followed the rules and the other side hasn't. And it's just a genius procedural device to make parties essentially point a gun and load it at each other and say, all right, yeah, go ahead, Mimi.
Or I was just sort of chuckling, or sort of a lighter comparison. It's sort of, when you're dealing with two small children, or sometimes older children, and you say, all right, you get to cut the sandwich, but your brother or sister gets to choose which side. It's just sort of the same kind of thinking, which is very wise. Yeah,
exactly. Very good. Well, in the interest of time, I may, unless there are other points on Chris, I don't know, Chris or Scott, further points on document production. Sorry, there's a question in the chat about whether due process paranoia affects the approach the tribunal has to document production. I might start on that and then see if others have. So due process paranoia, for those who haven't heard that phrase before, is the concern that arbitrators will essentially tolerate misbehavior by parties or unreasonable behavior by parties, allow multiple opportunities to miss deadlines and file things, or just say yes to whatever they're asked to do because they're concerned that their award will be overturned or will be set aside in challenge proceedings. So that's the phenomenon that's being asked about, and whether that affects the approach arbitrators take on document production. In my experience, that is not usually the problem at the document production phase, partly because document production decisions are rarely the kind of thing that give rise to successful challenge in most jurisdictions, certainly not in the United States. What I think is a bigger problem at document production is that if it happens at a stage of the proceedings where for whatever reason, whether because the parties haven't fully pleaded their cases properly or the tribunal for whatever reason hasn't engaged with it properly, you often find tribunals who aren't quite prepared to, as Mimi was saying, she looks for in arbitrators, really take the decision on this is relevant and that isn't. And so I'm maybe talking myself around to saying a little bit of yes, you can have that and you can have that too may come into it. It's there is a tribunal needs to have really understood what the case is about in order to rule thoughtfully on document production requests. And I'm not sure they always have, but I don't know, others might think that is more of a due process paranoia manifestation than I see it as them not really having gotten to grips yet with what the case is about, but others will have a different view.
Yeah, the only point I would add, which is maybe a similar one, is that because there's this fight about materiality to outcome, tribunals are wary of denying a request and sort of appearing to prejudge the merits by saying, well, that's not material, so we're not going to grant it. And so I think both factors lean in favor of erring on the side of granting requests rather than denying them.
Yeah, and as Liz, as you said, I mean, that's we go back to, so this is full circle almost, the earlier points about, in arbitrator selection, someone who's available, willing to roll up their sleeves and really dig in early, not wait till, they're approaching the merits hearing, and willing to make the tough calls and, maybe give them one pass or one opportunity, but just don't become a doormat because of the wrong, objectives in mind. It should be, an efficient resolution of the dispute versus kind of concerns over being, challenged. But yeah.
Right. Okay. Anything further on document production before we move on to presentation of witnesses? Okay. So another of the distinctive features of international arbitration practice is the degree of control that the parties have over the presentation of witness evidence. And I'd highlight just three distinctive features here real quickly to sort of set up the discussion. First of all, in arbitration, you can generally choose which witnesses you put up rather than worrying that witnesses that you don't call are going to be subpoenaed by the other side. There's a little asterisk there, which we may get onto, but generally you choose your cast of characters. Second, the rules of evidence are not strictly applied. So a witness can give hearsay evidence, and this is to serve the interests of efficiency, right? You don't need to have multiple witnesses come in to give their sort of minute perspective on a cumulative event. You can have one witness tell a coherent narrative, even if that involves her giving hearsay evidence about something that she heard from somebody else. And third, generally, the direct evidence or evidence in chief of witnesses is presented not orally by being examined in front of the tribunal, but in a written witness statement that is signed by the witness and attested to, but generally not sworn. It's signed under penalty of perjury, but it's not generally sworn. So I'm going to hand over to Scott to talk us through what he considers the biggest challenges and opportunities that that whole framework creates when it comes to presenting witnesses in international arbitration.
Yeah, thanks, Liz. So I guess like in most areas of life, the challenges and the opportunities are often the same things, but the the opportunity you have is to choose both whether to present witnesses and which ones. And the challenge there is to figure out, well, first of all, do we need a fact witness on this? And then if so, identifying the right one. And so taking the first part of that, well, do we need a fact witness? In sort of the best case, you don't need fact witnesses. You can make your case on the documents. And so there's the sort of random uncertainty surrounding fact witnesses you can avoid by relying on documents alone. So sort of when do you decide you need a fact witness? Well, typically you're looking for either parts of the story for which there is no documentary evidence, or where the documentary evidence is confusing, difficult to understand, where you need somebody who was there living it to tell the story. And in that context, what is your opportunity? Well, you can have a witness there to tell a story that maybe doesn't leap off the page of the documents, and in a way that's more compelling than coming from the lawyers. Now, that said, it's ordinarily the lawyers who are drafting it, but they're drafting it based on interviews with the person who can, who's the one that's really defining the story. The lawyers are just kind of organizing it and packaging it. But, and so that collaboration can be very effective in allowing you to present what would otherwise be a sort of confusing mess of complicated documents in a narrative that says, this is what happened, this is what we understood to be happening, we did this, this is why, the other side said this and we disagreed, and this is how it all played out. And so you can get that story in a kind of narrative format that's easy for the tribunal to absorb. Now, the challenge, of course, is your witness is going to be cross-examined. The other side may be putting in counter witnesses. So one of the things you really need to be making sure is that the evidence is robust, that both the witnesses' recollections are stable, accurate, that, and one of the key features for me in thinking about whether someone will make a good witness is whether they know what they know, and whether they can distinguish between what they know because they were there and what they know because they heard it from someone, or because they have an understanding of how the world works. That means they inferred that this must be what happened. And people who, not everyone is good at distinguishing those ways of knowing things, but a good witness will, and a good witness will say, okay, I was at the meeting, this is what I said, this is what they said. And then they will say, well, I wasn't at that other meeting, but this is what I was told, and this is what I understood to be happening based on whatever they're basing it on. And so they're giving the tribunal evidence that the tribunal can use, and they're not exposing themselves to the sorts of cross-examination questions that will really make their evidence not be credible and relied on. So, and I guess that leads to the question of what can and should you do to be, when you have a witness, they've told their story, and how do you get them ready to testify at a hearing, which is both a challenge and an opportunity, because the witness, they may get it, they may make mistakes, they may crumple under cross-examination, or they may hit it out of the park. They may be really really good at the role of being a witness, which is an unusual role. Most people have never done it before, so you don't know how someone's going to perform. And so the key thing when you're preparing someone is to remind them that they're there to tell what they know. They're there to help the tribunal by telling them what they know. They shouldn't be arguing with the counsel. They shouldn't be resistant or obstructive, or just answer the question, but also no more. You don't need to go beyond what's being asked and offer all kinds of other explanations, which may take you off the terrain of what you know and what you should be talking about. So, but if you do all of those things right, it can be a very effective way to get the client's story across to the tribunal in a way that the tribunal feels comfortable relying on that evidence.
Just a quick follow-up question. Sorry. Just a quick follow-up question, Scott. I mean, I think there's sometimes a tension in arbitration where we've talked about the benefit. I mean, Chris flagged this, the benefit of the efficiency, the time and cost efficiency of it. And just the reality that, we don't have often weeks and weeks of hearing time. We don't want to have a dozen witnesses. So we will take advantage of the ability to have one witness tell a slightly broader slice of the story, perhaps, than we might if we had a 2-month trial, right? And at the same time, that very good advice and that very right perspective that you just shared, which is to keep a witness focused on what he or she knows, right? And I think that getting that balance right, sort of helping the witness understand the story they're telling and how sometimes it is that tiny bit larger than just, Mr. Vessel, do you know the time? Yes, I do know the time. You need them to go that one step beyond, but not several steps beyond just answering the absolute minimum question and nevertheless carrying a little bit of the narrative. Because we don't call every witness who was at the meeting. We don't have to do that. We don't have time to do that. We don't want to do that. But at the same time, keeping them grounded in what do I know and how do I know it? I think that is both a challenge and, as you say, an opportunity in arbitration. I don't know, Mimi, if you have a different take on that, or how do you approach preparing witnesses for?
Yeah, and I mean, I don't think a different take on it, but I mean, here's just another, I guess, plus in the arbitration column, right? It's just so much more efficient in terms of the presentation of the witnesses, because as I think Scott walked us through, there's an exchange of your witness list. Granted, you have that in litigation in some fashion, and then witness statements. And so it really is a great way to ground, the tribunal and your counterparty on what this witness, this is what Liz is going to talk about. And it's sort of, this is part of the story versus in litigation, you call Liz up and, she's there on the stand like all afternoon, laying the foundation, this is how long she's worked there. And this is, and that's, that can be a snooze fest, particularly for a jury, that they're sort of lost. Like, why are, the lawyer, walks away thinking, oh, I made such great points. And the jury is just sort of like, what just happened? Why is this relevant? Whereas, in arbitration is very focused. It's, you really kind of narrow the field of what's relevant. Do I need to even call this witness live or not? And there's huge efficiencies there. But, I will say, and you ask about prep, that can be tricky depending on what jurisdiction you're in, and a little bit confusing. And I'm sure most others on this call are far more expert on this than I am. But, under English law, which is very different than, our jurisdiction here in the US in terms of, preparing or familiarizing, a witness in advance of a hearing and what you can and can't talk about it and can and can't do. I mean, that is tricky. And so for a witness who is not experienced in testifying in cases and disputes, they're just, normally just doing their day job, that can become tricky, coupled with, the last 2 years doing virtual prep and virtual hearings. I mean, you talk about loss of any amount of control. That can be tricky. But, again, I think if you using Scott's, good pointers and just keeping it very simple, even if you can't prep or train a witness, I can't remember what phraseology they use, but and you're just limited to familiarizing themselves with the process. It's only talk about, you'll be asked to do this. You'll only talk about what you know. We're not going to get into the details, but this is, and maybe you can get around it, that way. But that is very different than what we would do in the U.S. in litigation or arbitration. Really, we'll do practice sessions, mock sessions, that kind of thing, which can be really helpful. Usually in any witness prep session we've been involved with any of our witnesses, they come off the stand and 90% of the questions we ask them in mock never even came up, right? Because everyone wants to be over prepared. So that can be a challenge, but I think in terms of presenting a witness in arbitration versus litigation, I think it's much more narrowed, much more focused. Should be less surprises, and it's just far more efficient. And I would also say, if I were talking to an employee from my company who is going to stand as a witness, it's typically a little bit more civilized, than in a typical U.S. courtroom style litigation. And maybe folks, it's the lay people have seen too many TV dramas about cross-examination and tears at the stand and that kind of thing. But it's typically a little bit more civilized and humane, I guess. But I think that also is because of the efficiency piece of it too.
Right, Scott, is that I know you to be a very civilized individual. Is that characteristic of how you approach examining witnesses in arbitration? Would you say that the tone is overall different to how that practice goes down in court, or are there other distinctive features of examining witnesses in arbitration that you'd highlight?
Well, maybe one distinctive feature is that tribunals tend not to be very strict about what's fair game in terms of questions. So there will be opportunities to object to questions, but tribunals tend to let it go. So it's not like, a sort of a court case where you will be there are sort of strict rules of evidence and objections where a question is out of bounds. It's a lot more fluid in arbitration, and that can be good and bad, but it's just something to be aware of. And maybe coming back to one of the things Mimi was saying about sort of different jurisdictional rules. And I think the position in England is shifting because of the perceived, they didn't want to be at a disadvantage where you have a party with English counsel who's sort of not allowed to do the same things that their opposing counsel can do. But one of the things that is important to include in the procedural order number 1 about how the proceeding is going to unfold is a paragraph that makes clear a shared understanding about this. So you'll typically include a paragraph that says it is understood that it's appropriate for counsel to meet with witnesses for the purpose of preparing their witness statement and familiarizing them with the case in advance of their oral testimony, or something like that, that says, you can do this and it's not going to be inappropriate. Now, that said, there are limits. You're not allowed to coach a witness about what their answer should be to a question, so that it's not a complete free-for-all. But it is important to be clear that the sorts of things we're talking about drafting the witness statement and running through some mock questions, here are some questions you might be asked. You want to be clear that that's all fair game, so that it doesn't create a big mess at the hearing.
Very good. Well, we've got about 15 minutes left for the session. I don't know if there were any questions in the Q&A, or Nathan, if you had any collected from the participants.
Hi, Liz. Yeah, I have a few questions right now. Some of them may put you on the hot seat. I hope that's all right with you.
Fine.
I think maybe starting off, a question for you. I'm wondering if you feel that there's a difference between arbitrations with state parties and commercial parties that would be really helpful in sort of elucidating for everyone's edification.
Yeah, I do handle a lot of cases involving one state party on one side and a private party on the other. I think I would identify probably at least 2 key differences. One of them Mimi already alluded to, and that is that a case against a state party or where a state party is involved is probably marginally less likely to settle before there is an award. It's not impossible, but very often state parties, for a variety of reasons, given their internal decision-making or internal political dynamics, will find themselves, particularly once a dispute has percolated up to the level of a notice of arbitration, will find it difficult politically to make a decision to pay a large amount of money or to give up on a large claim against an investor, for example, without there being an order that they should do so. And so in my experience, cases involving state parties tend to go, if not all the way to a hearing and to an award, at least through a hearing. Sometimes they settle after a hearing, sometimes they settle right before a hearing. Often they will be resolved by agreement after an award in favor of the non-state party. So they can be resolved amicably, but often they will need some clear indication of the direction of travel from a tribunal. So they tend to run longer, and they tend to need some clear signal that the handwriting is on the wall. There is going to be a finding of liability. There's going to be some money attached to it, and therefore that provides political cover for decision makers within a political system to say, okay, now it's time for us to sit down and actually make a decision. So that's one way in which proceedings involving state parties, I think, are different. Another way in which proceedings involving state parties are different is that any time estimate you give for how long a typical arbitration will run. So you might say a typical commercial arbitration might run 18 months. If you have a state party on the other side, I mean, it's a little bit of a joke to say double it, but not really. State parties typically are given, ask for and are given more generous timetables. They will quite rightly point out that they have other things that they are responsible for, including the running of a state. And so they can point to just internal processes, bureaucratic processes that are slow and careful and must be transparent. And, you know, and so at any point in the process, including the very beginning where they receive a notice of arbitration and need to appoint counsel, there is the opportunity for delay to be injected in the process. So they will say, we need to go to a public tender process. That's going to take 6 months. So states have a long list of ways they can slow a proceeding down and apparently legitimately slow a proceeding down. And tribunals will be deferential to that. I will leave to one side whether I think that's always appropriate, but they will be deferential to that. Transparency is a third thing I should mention. I think increasingly state parties will either have signed up expressly to obligations, either in national law or international law, for their proceedings to which they are parties to be made more public than a typical commercial arbitration might be. And so there will be a dialogue around transparency in cases involving state parties that you wouldn't typically find in a commercial arbitration. So that's a new that's a factor in dealing with cases involving state parties. And then there might also, depending on the character of the proceedings, be an opportunity for non-disputing parties, essentially amicus, who have an interest in the outcome of the case, depending on what the issues are in the case, to try to participate in the case, to essentially make submissions about implications of the case for other interests, environmental interests, or indigenous communities, or any number of other kinds of interests that might be implicated. So there's some of the ways in which cases involving state parties are different. I don't know, I know Mimi and Scott and Chris might also have I know Mimi and Scott do have experience of cases involving state parties.
Really appreciate you elucidating that. That was a lot of information right there. Hopefully, if we have enough time, I'd like to ask a question from Chris right now. This has to deal with privacy and cybersecurity concerns, because you're often quite familiar with that. It's my understanding international arbitration has been on the rise in the past few years, especially for tech companies. And I'm wondering if you could tell us a little bit more about why a lot of tech companies have been moving towards the international arbitration route, especially due to privacy and cybersecurity concerns.
Yeah, that's a huge consideration when it comes to this topic. I think because of the shift toward privacy and cybersecurity being top of mind for attorneys and for parties that are involved in legal disputes. It goes back, number one, to privacy that we just talked about, where sometimes when you have a huge lawsuit, it's quite public. There's a lot of information that's out there. There arguably are quite a few people that are involved in the lawsuit that are not necessarily well trained in best practices when it comes to cybersecurity and data privacy, right? And so I think you see mega behemoth corporations that are still struggling to keep up with the simplest of GDPR regulations that have been around for almost 4 or 5 years at this point. So to entrust a court and court officers and other people who are also involved in other parties and multiple people with information that is arguably extremely important to your company and to the people that work with you and for you is a huge ask. So that's why you look at arbitration and what we mentioned earlier with some of the best practices, some of the training that arbitrators receive, the staff that are trained in privacy and confidentiality practices, that makes a huge difference in how these things move forward. And another aspect to consider is the subject matter that's also being discussed. We didn't talk about that much today, but if we're talking about an IP dispute, for example, intellectual property often goes one of two ways. You either do not want a lot of people to know what the fight is about, and so you want privacy, you want the clampdown of what arbitration can give you, or in some situations, for example, Apple, Samsung, you want the public to know about the proceedings, and so you file publicly, you have a huge lawsuit, and that's how it goes forward. But I think in general, arbitration is much more favorable when it comes to the new age of tech advancements. And you have so many different tools, you have so many different cyber and data privacy related advancements that really help keep information private and secure, in my opinion, a lot better than they would be when as opposed to in litigation. So that's a huge benefit for arbitration. And I think, again, depending on how the parties are dealing with each other, it gives you the opportunity to be much more careful with the data that you are sharing, because after all, regardless of the fact that it's a dispute and it's a legal dispute, you still have multiple data privacy obligations. You have obligations for cross-border data transactions. You have so much information that you need to look after, and arbitration gives you a little bit of an edge in that category, because it allows you to control the data a lot better than it would in litigation.
Thanks so much, Chris. I think that's really helpful. It clarifies a lot. I'm now wondering if I could ask Scott a question. So before we had this webinar, you mentioned that you had a lot of experience involving Eastern Europe and former Soviet Union countries. And you mentioned that you had a few thoughts about maybe what to expect in the near future, and there may be everything from COVID and all these other contemporary political events that have been going on. Do you feel like there's anything in the near future that you think we should be paying attention to when it comes to the arbitration space?
Yeah, thanks, Nathan. So I think there are a number of things going on that we can expect to give rise to disputes. When those disputes will emerge into arbitrations, it remains to be seen. But the first thing that happened is you had sanctions in response to the invasion of Ukraine, which have generated force majeure circumstances under a lot of contracts, and you have prohibitions on certain kinds of transactions, and so you can see a ripple effect of the sanctions, the war itself interrupting performance of contracts, giving rise to contractual disputes about what is or isn't force majeure and what sort of performance could happen. You've had developments in Russia, in particular in Russian law, that have affected the arbitration space in a number of ways. You have, first of all, they had an amendment to their arbitration procedural code, under which a Russian sanctioned entity can get out of its arbitration agreement and go to Russian courts instead. you have nationalization legislation working its way through the Duma, where foreign investors who are stopping their operations in Russia risk having their assets taken. You've had separate decrees about intellectual property and things, and you've had the first wave. We've seen foreign investors selling their operations in Russia at sort of fire sale prices in sort of mysterious circumstances. So they're with the Russian state saying it's a nationalization and the company saying it's a sale. You know, the circumstances are not public, so it remains to be seen whether we'll see, you know, investment treaty arbitrations or other things arising out of that. You know, and then another thing going on is that the Russian invasion of Ukraine has resulted in massive destruction of property and resources in Ukraine. And so how the losses associated with that will percolate through the different legal systems, including arbitration, you know, remains to be seen. But I think there's a lot happening in that space, and it will be interesting to see what shakes out in terms of what types of disputes actually make their way to arbitration.
Thanks, Scott. That's really helpful. I think maybe for a last question, because we have a few remaining minutes, Mimi, I'm wondering, maybe this question, if you feel that you could go on and give a whole lecture, maybe someone else can cover it. But you mentioned earlier,
someone else can cover it. I'm kidding.
There are some distinctions, you know, that mentioned previously between US and UK rules regarding witness preparation, that there may be some regional variations or particular norms governing the approaches going on with international arbitration. Do you think there's anything that lawyers should be keeping in mind when they're sort of involved in these sort of regional variations regarding norms concerning international arbitration?
You know, other than the comments I previously made, I guess I would just add that, you know, for my team, we manage international disputes, both litigation, arbitration, all over the world. So, and we're all US trained and born, raised, you know, lawyers. So we couldn't possibly be expert in every single jurisdiction out there, right? And so, but, you know, we're often asked that question, well, how are you able to, you know, get involved and manage disputes, you know, all over the world? And, you know, number one, we rely heavily on our local counsel and to help guide us, but also we sort of try to bring to that experience, you know, our training as a US lawyer. And even though, you know, procedural rules are different, you know, we can test it a little bit that way and see, are we really, are we staying within the bounds, or is there room to kind of push the limits a little bit to make sure we are robustly prepared, you know, for any dispute? So, I mean, and then in another way, I mean, just going back to sort of the differences regionally, you know, you do need to be sensitive to that always and make sure you're not unintentionally putting your witnesses at risk. In some jurisdictions, and I won't identify them, we've learned that, wow, okay, you can actually, you're encouraged to do, you know, X, Y, and Z. So it just, you know, goes to show you just, I mean, it's not one size fits all, and you need to be knowledgeable or become knowledgeable and get the right advisors in front of you who are understand the procedural rules, limitations, are, you know, ethically responsible, so that they aren't unintentionally getting you or your witnesses or your company in trouble. But I'll hand that up to the other experts if they want to add to that.
Well, I really want to thank you for that. I think, Liz, did you have something you wanted to say?
No, I just wanted to say, I think it's absolutely the case that there are, as you rightly identify, Mimi, there are practices and pitfalls and opportunities in different jurisdictions. I think one of the things about international arbitration is that what it can be is a sort of, you know, 80% the same most everywhere you go kind of process for resolving disputes. And there are regional variations, right? If you have a tribunal that is made up of 3 German lawyers, they will conduct the process slightly differently. They will comport themselves slightly differently, but it will look very much the same as a process that is conducted by three English lawyers, but actually, no, that's not right. If you have a tribunal that is made up of one German lawyer, one US lawyer, and one English lawyer, it will look pretty much the same as if it is one German lawyer, one French lawyer, and one English lawyer. The whole point is that it is a transnational, a broadly similar process. It is broadly recognizable to broadly, a group of users who can engage in a process that is reasonably familiar. There are differences around the edges. There are different people who come from different legal cultures will have a different orientation towards how active a decision maker might be, or exactly what role counsel play, or how far they go in mock cross, for example. But I think what the system offers is this, broadly recognizable dispute resolution service that you can find here and you can find there. And that to me is what is one of its greatest appeals.
I think that's probably a good point to end everything on. So capping everything off, I really want to thank Mimi Lee, Managing Counsel at Chevron, Christopher Gazarian, General Counsel at DreamHost, Scott Vazel, and Liz Snodgrass, partners at Three Crowns, for taking their time to speak with us today. It's been really helpful and super enlightening. Wishing you all the best.